Well, hello there, and welcome to the Disability Law Show. Good to have you along for the ride. John Scholes, along with James Fireman, Tamar Agopian, both of them from Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. You can reach out anytime beyond this half hour, of course, 1-855-821-5900, help@disabilityrights.ca, or just the website disabilityrights.ca for more contact. We got some email questions coming up. We got all kinds of information to give you out over the next half hour via James and Tamar. And we will get to our main topic in just a bit. That is what you must know about LTD if you're suffering from depression. That is just in a little bit here, but we always start off with the week that was. Guys, James, I think you're going to throw this one out there. So what do you got, sir?
Well, so there's a couple concepts that keep coming up repeatedly with new people that are calling me or clients that I already have where mediations are coming up. And they're asking about things that the insurance companies are doing that don't seem to make sense to them. I call them hidden motivations. And so I thought it would be a good opportunity to discuss some of the behaviors that we see on a regular basis that the insurance companies engage in that just don't seem to make a lot of sense. And one of the ones that comes up all the time is what happens right before the 2-year mark. So when someone has been paid disability benefits for almost 2 years, we often see a lot of things happening on the file. Usually in the months leading up to that, we're going to see the insurance companies start doing things to adjudicate the file in a way that they haven't done over the first year or so. And the reason for that is because at the 2-year mark, there's what we call the change of definition. The test changes at that point from whether or not you have a disability that prevents you from doing your own occupation to whether you have a disability that prevents you from doing any occupation. And when that test changes, the insurance company wants to know whether it has enough evidence, enough justification to cut off your benefits, because ultimately that's what they're looking to do. And so very often you're going to see them do things like send you for a functional abilities evaluation or send you for an independent medical evaluation. And the objective there is for them to get an opinion that suggests that you are capable of returning to work in any occupation. So you see that type of behavior, and you'll also see insurance companies very frequently, just before you hit that 2-year mark, decide to cut off benefits. We see that happen far more frequently than at any other point. And it may seem strange. Well, why are they cutting me off a week before that 2-year mark? And the reason is because if they keep paying you benefits after the 2-year mark, then they have to justify why they thought for some period of time you were in fact disabled from any occupation and they no longer do. And that is a tougher thing for them to be able to justify down the road if they cut your benefits off past the 2-year mark. So we do see that behavior quite frequently where an insurance company will cut someone off just before the 2-year mark, and that's why. And of course, if that happens, we're certainly there to help, and there are often many things that we can do, especially once we get a hold of the insurance file and we can see what went into that adjudication in order to bring a claim and successfully get our clients what they're entitled to. There's another situation that comes up quite frequently, especially, of course, over the last few years, and I'm talking about COVID. COVID cases have come to us in many different forms, but the one that seems to be much more prevalent these days is long COVID. People who have contracted COVID at some point over the last 2.5 years and have continued to suffer with all sorts of various symptoms, but most commonly we see chronic fatigue, general body pain, and cognitive issues, cognitive dysfunction that is preventing people from being able to do their jobs. And what we see almost across the board is when there is a significant element of COVID in the diagnosis. So when you first apply for a claim, your doctor is going to fill out an attending physician statement and list off what is wrong, why this person can't work. And if an insurance company sees COVID on that list, almost invariably they're going to deny whether or not there's actually a disability there. And my thinking on that is quite simply that there are so many of these cases out there that if they start accepting these claims, they're going to start making a lot less money. And so we see that all the time. They almost invariably will deny across the board if COVID is one of the primary reasons for applying for disability. But that doesn't mean it's not a legitimate basis. I'm quite certain that it is. Whether or not there is a test right now that can prove that there's long COVID, and they're working on it, But whether or not there is a test available right now that can prove you have long COVID or not, the issue is whether or not you have symptoms, whether you have a functional disability from being able to do your job. And if it's because of long COVID or anything else, you'd be entitled to benefits. And so the issue is we see these insurers denying on the applications, but then when people call us and we take on these claims and we bring them into litigation very quickly, the insurance companies are very ready to come to the table and pay a reasonable amount. And I think there's a hidden reason for that. They don't want to pay on the application because they don't want people applying for those benefits if they have COVID, but they also really don't want any of these cases going to trial. And the reason for that is because as soon as one of these COVID cases goes to trial and a judge decides on it, if a judge says that COVID is in fact something that you're entitled to claim disability benefits for, that becomes a public decision. That becomes something that everyone across the country has access to, and it's something that will make national headlines. And all of a sudden, every person who believes they have long COVID is going to be applying for disability benefits. So they have a great interest in ensuring that those cases never reach trial. And the way they do that is by coming to the table and paying what they should have done in the first place.
Is it ever an issue, your vaccine status? Have they tried to pull that card? Well, you're claiming long COVID, but you're not vaccinated. You should have got vaccinated. We're not covering you.
It can, absolutely,
Really? Yeah.
it can. I mean, I think it's become a bit of a political hot button topic, and so it imputes a lot of these preconceived notions about the type of individual who may or may not be vaccinated, the type of individual or profile who may be seeking disability benefits related to these COVID claims. And so, unfortunately, as James said right from the start, sometimes these notions, motivations, and things that really don't have a lot to do with the disability claim itself will influence what an insurance company may or may not do in terms of approving your claim. And invariably what we're seeing is a lot of resistance at that adjudication phase to actually approve these claims and keep them in approval mode to wait out the types of treatment and other things that these types of individuals need. It's kind of more of a holistic approach because a lot of these disability claims are multifactorial, right? Mm-hmm. And there isn't a clear A to B to get diagnosed and then have resolution. And there's absolutely a resistance by insurers to approve these types of long COVID claims.
Wow, crazy. PocketEmploymentLawyer.ca, that's a website we bring up on this show. Now, normally it's on our sister show, the Employment Law Show, but it's also useful here because there's a section on it that has to do with disability law. Tamar, you've used it before, yeah?
I have used it before, and this is the genius that is, Lior, one of our founding partners. He conceived of this Pocket Employment Lawyer, and initially the idea was to allow people anonymously to go onto this browser, to do a plug and play, very easy, to put in information to see whether or not, they may be entitled to severance and what that severance might look like. But there's an add-on feature to it as well, which is that you can very quickly determine whether or not you've got a basis for a disability claim as well. So if you are wondering, look, I don't really want to necessarily speak to a lawyer, absolutely fine. Although our consults are free and you can speak to any one of us. If you just want to see, look, let me put a little bit of information in here and determine if there's a basis for a claim or an issue, Pocket Employment Lawyer is the place you want to go. Plug and play, very easy. You don't want to talk to us, click off the browser, you're done. We wouldn't even know about it. We're not going to call you. We're not going to contact you.
You also got the option of an email anytime, help@disabilityrights.ca. First one for the day, guys. Min writes in, says, I have a compression fracture in my back that is causing me pain and instability, preventing me from working for the past year and a half. I was an assistant in a pharmacy and spent most of the day on my feet. The insurance company accepted my short-term disability claim, but denied my LTD. I've appealed 2 times, and I keep getting the same response, no. Is there a better approach?
There is absolutely a better approach. I'm going to suggest to Ben that the better approach is a legal claim, but I want to unpack this a little bit, John. Mm-hmm. And so for those who might be new to this realm, and many people are when they're dealing with disability insurers, they don't really know what to do. They will initially apply for short-term disability benefits. Usually that's through their employer. The forms will be submitted, and away they go. The employer may or may not have a third-party, adjudicator, or maybe it's an insurer looking at their disability claim. But it doesn't necessarily mean that just because your short-term claim is approved that you're going to naturally transition to long-term disability benefits. Sometimes you actually need to make a separate application directly to the insurer who approves and pays these types of claims to get that application going and have the insurer actually make that evaluation. So it can be bumpy, in other words, is what I'm getting at. But it sounds like from Min's perspective that bumpiness has persisted through various appeals. And I think there's a little bit more going on. And I suspect that even if the insurer was involved at the initial phases of the disability claim, and maybe they were involved in the short-term claim, if it's the long-term claim, you can bet that it's the insurer actually paying those dollars. And sometimes they act as gatekeepers in situations like this, and they will resist the transition from short-term to long-term. But they shouldn't, John, because the test to qualify is absolutely the same. It's total disability from Min doing his pharmacy assisting position, and whether or not that's for short-term disability benefits or long-term disability benefits, he should have been approved across the board. Because when I see a profile like this, an individual who's got physical symptoms with a disability that really would prevent him, like a back condition, from doing the substantial duties of his job, then to me it's fairly routine. He should absolutely be getting his disability benefits. So I think the insurer is trying to resist, perhaps trying to see whether or not this will persuade him to perhaps go back to work, or not go back to work at all, but at least not bug them anymore, which is why they offer appeal after appeal. And so the most efficient route in situations like this is, look, you really do want to assert your rights in a legal claim. It is absolutely the most efficient route from A to B to get the insurer to come to the table reasonably and really look at it. And I think the fact that he was approved for short-term is yet another log on the fire that he absolutely should have been approved for the long-term claim.
Doesn't matter if it's the same insurer for both or different?
It can make a difference. If it's the same insurance company, then it's much more difficult for them to justify why the same test doesn't apply after it switches from short to long term. So there is at least more ground to stand on if it's a different insurance company. But I can't let a question like this go by and not spend at least a little bit of time on the whole appeal issue. I know you touched on it, Tamar.
I fully expected you to, James.
I know. It's, you know, you knew I was going to bump on it, so here it is. I mean, listen, man, don't appeal. You are wasting your time. You have to consider what the insurance company's motivation is in all of this. And insurance companies are corporations. They are in business to make a profit for their shareholders, and that's fine. I don't begrudge them that. But you need to understand that when you're dealing with an insurance company, that their motivation in everything that they are doing is to turn a profit. And how do they do that? Well, they do that by paying fewer benefits, by proving fewer claims, and by taking in more premiums. And so when they're adjudicating files, they are actively looking for reasons why they can deny a claim. And if they find a justification, if they find anything that they believe can hold up to the most superficial review of why they should not have to pay benefits, they're going to hold on to that with everything that they have. The only way you're going to get them to change their mind on an appeal is if you provide them with information that so fundamentally changes what they already know. If you're talking about something that's undiagnosed in your application, and then through the appeal process, there's now all of a sudden a diagnosis of cancer, okay, then maybe you have a shot, not a guarantee, by the way, maybe you have a shot at changing their mind. But short of that, you're just wasting your time. All you are doing is delaying the inevitable. If you want to get the benefits you're entitled to, you're going to have to bring a legal claim, because that is the only way to get them to the table where they do not have control over the process. And until you remove that control from them, they're just not going to act reasonably. And once you bring the legal claim, all of a sudden, they're ready to talk about what you're actually entitled to and come with actual money to pay your claim.
Coming up, applying for LTD due to depression. We'll get to that after a short break, what you need to know. In the meantime, as Tamar mentioned, reach out anytime, 1-855-821-5900, help@disabilityrights.ca. This is the Disability Law Show. Lots more coming up. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, Don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Disability Law Show. So good to have you on the show again today. John Scholes, along with James Fireman and Tamar Agopian, always here giving you the correct information. You can reach out anytime as well. If you're unsure about dealing with that long-term disability insurer, try the phone call, 1-855-821-5900. Emails help@disabilityrights.ca. And for short, easy-to-read, non-legalese, concise memos all about LTD, LTDFAQ.ca. Guys, let's get to this. What you must know about LTD if you're suffering from depression. Number one, if your doctor agrees that your depression is impacting your ability to work, you should apply for LTD benefits through your insurance provider. Tell me about it.
Absolutely,
Yeah.
because that is exactly why you're paying premiums. And even in group policy settings where someone has disability benefits, John, through their employer, it could be a copay situation where you might be paying for part of it, the employer might be paying for part of it. Either way, the benefits are there for a reason. And if your doctor is saying you cannot work as a result of your health conditions, then you should absolutely initiate that disability application. And in fact, I'm going to take it a little bit further from that. I'm going to suggest to all of you that, and the courts have said this, these disability policies are meant to be a peace of mind policy. That's what it's there for. And the fact that so few people feel that they want to move that needle with the insurer and actually make that application is disheartening to me, because this is exactly the reason why you need disability benefits. When you cannot work, it's an income support so that you can focus on your health, try and recover, and get that monthly disability benefit paid through the disability insurer.
I think it's especially relevant when we're talking about mental health issues like depression, because there is a stigma that is attached to it. It's not like it used to be. It used to be much, much worse. It is getting better, but we're not at a point now where everybody feels comfortable acknowledging that they're suffering from mental health issues, and more to the point, actually seeking help for that and applying for insurance on that basis. That is still a step that a lot of people are just not prepared to do yet. And my hope is that by talking about it openly, especially if you've got encouragement from your doctor, that people will feel a little bit more free to come forward and to make those claims, because you are entitled to it. Mental health disabilities are disabilities. They are absolutely as real as a physical disability. So if you are suffering from a mental health disability, you should absolutely be applying for your benefits. It is not the case that those are only for people who have real disabilities. That is not the kind of language that we use. When we see that, we're going to bump on that, because mental health disabilities are 100% legitimate, and we know this as people, but we also know this because the courts have held this over and over again. Insurance companies have to treat mental health disabilities the exact same way they treat physical disabilities.
Number 2 point is this: make sure you have thorough medical documentation and follow all the treatments prescribed by your doctor or your medical team, right?
And this really ties into what I was just talking about, because there is still this stigma with mental health issues. And so when we're talking about mental health, it becomes more important to have that documentation. So this is difficult for people, but it is really critical that when you are suffering from mental health issues, that you seek professional help and that you make sure that your symptoms are well documented, that you are sharing those with your doctor, and that they are going into the clinical notes. And those clinical notes are going to provide the foundation of your claim. And so initially, it probably starts with your family doctor, but hopefully there'll be a referral for either a psychotherapist or perhaps a psychiatrist, whichever is going to be most appropriate depending on what mental health issues you're dealing with. But it is really important that those records are complete and thorough and provided to the insurer, because without it, it is far too easy for insurance companies to say, okay, well, there's nothing there in the notes and records, and I don't have an x-ray that shows your depression, so we're not going to approve this claim.
The devil really is in the details, and I can't echo enough what James has said, is that yes, for any disability, You want the doctor to ensure that they are documenting symptoms, especially when you've got a claim that's very focused on subjectivity. In other words, mental health being one, chronic pain, chronic fatigue, even the long COVID symptoms that we talked about at the top of the show. It is very easy for the doctor to simply not record everything that is going on with someone's health issues. And you don't want that necessarily, because I can assure you, adjusters and claims managers, the people who are looking at just the paperwork, they are very focused on those details. And sometimes the absence of these kinds of symptoms being documented in these medical records will allow them to suggest that it's just simply not that pervasive a problem, or something that's not really happening. The fact that it ends up in a medical report validates that these symptoms are in fact there. They're being treated or addressed by the doctor or whoever you were seeing, and therefore the basis for the disability claim.
Again, what we're talking about, what you need to know about LTD if you suffer from depression. Third point is this, guys. Talk to a disability lawyer immediately if your LTD is claimed or has been claimed or been cut off, or you've been told to return to work or appeal for the 15th time. Right, James?
Absolutely. And so this is the challenge, is that I don't want people to feel that resistance to actually talk to us. These consultations are absolutely free. We will take as much time or as little time as you want to talk through your issues and just really talk through the problem and figure out, look, are there things we can do right now? Are there things we do in a few months from now? Either way, we have a lot of experience on our team in dealing with all sorts of types of different disability claims. And it's not that hard for us, frankly, to look at maybe what you submitted with an LTD application, maybe a couple pieces of medical information, maybe even just the policy or the denial letter from the insurer. And when we can really easily unpack that, find the gaps, and really give you a great place to start, which frankly is going to be most likely a legal claim for the vast majority of people, John. Because the last thing I want individuals to face is perhaps gaps in medical treatment. They're struggling with their health. They're waiting for a referral, perhaps to see a specialist. And in the midst of all of that, the insurer's saying you just simply don't have enough medical information to support your claim. So we're not going to issue that monthly benefit. So now the individual is not only struggling with their health, but you layer on top of that all of the financial strains that come with that. Let us be part of that solution. Let us help you move that needle with the insurer. We take one of those issues off the table, and then we start that legal claim.
I think it's also really important to, again, remind people watching at home, we recognize that if you are suffering from depression, again, a lot of people are not going to want to put a name to the face or to the voice, and they want to at least start out anonymously. And that's really why we have all of these different ways to get in touch with us. And you can start small. You can start by going on to the Pocket Employment Lawyer and just taking a look at, okay, what might this be worth? Or you can ask a question a little bit more directly, but still anonymously, on the mydisabilityrights.ca. Or you can call and get a consultation with one of our lawyers and get information that you don't need to do anything more with. You don't need to provide a credit card. You don't need to pay for the consultation. It can just be about getting information. And once you have that information, then you can decide what you want to do. And if you want to go ahead with a legal claim, we can help with that. But if you don't, that's perfectly fine. No one's going to be upset with you. The idea here is you choose what is going to be most comfortable for you in terms of getting that information that you need to figure out what the best path forward will be.
Coming up, guys, after a short break, misrepresenting our health history when applying for LTD. That is on the way, but in the meantime, the number again, 1-855-821-5900, help at disabilityrights.ca, or simply disabilityrights.ca. As James mentioned, you can reach out there anytime you would like. More of the Disability Law Show just ahead. Stick around.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back, Disability Law Show. That's what you are watching. John Scholes here, and with me, James Fireman, Tamar Agopian, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. You can Google that. You can reach out anytime to these two. They got a great team behind them. Phone number 1-855-821-5900. You can use the email help@disabilityrights.ca. And there's also a website called mydisabilityquestions.com. That one, again, free and anonymous. It's searchable, so maybe your question has been asked previously. You can just search for it, save some time. If not, leave it there, and it'll get answered. Connor, in that regard, guys, is here, says, the insurance company says I misrepresented my health history, and now my disability coverage is void. I don't understand why they're saying that. I'm confident that the medical documentation I sent to my insurer is correct and up to date. What do you think?
Good question, Connor. So first of all, for our people watching at home, I want to assure you that this isn't something that most people are going to have to worry about. If you have disability benefits as part of a group disability policy, this is almost certainly not going to apply to you. I'm almost positive that Connor has a private disability policy. In other words, he didn't have a group policy at work, or perhaps wanted additional coverage and went out and bought a separate policy on his own. When you do that, when you buy a disability policy on your own, in those situations, you have to submit to a medical questionnaire. So sometimes they'll even have a nurse come down and do a physical on you, but at the very least, they're going to ask you questions about your health history, about your smoking history, about what you've done, what risks you've taken, and so forth. And based on that, they're going to determine whether or not they're going to even offer you coverage at all, and if so, how expensive the premiums are going to be. That's all part of the underwriting process. And so what happens is, if you bring a claim down the road, they're going to take a look at that application and see whether or not there's anything on there that wasn't entirely true. It doesn't necessarily mean it was intentional, but even if it was unintentional, if there's information on there that was incorrect and that would have affected the underwriting process, in other words, might have led the insurer to either not provide the benefits at all or to require a higher premium to get them. If they can show that, then they may try and void the policy. But here's the thing. They can't do that forevermore. When they validate the policy, when they say, okay, you have coverage, there is a 2-year window. If you don't bring a claim within those 2 years, unless you have committed fraud, unless you have intentionally misled the insurer about something that is material, something that would have affected the underwriting, then it doesn't matter whether there was something incorrect or not. After 2 years, that policy is valid and there's nothing that the insurer can do about it short of fraud. Within those 2 years, however, and I suspect this is what's happening with Connor, they can challenge the validity and they can take a look at whether or not there was something material in the documents or the evidence that you gave them in these applications that would have changed their underwriting, that would have affected whether or not they would have issued the policy. And so my suspicion is that in this particular case, that there might have been some information that they're saying would have affected their decision. Doesn't mean it's true. Doesn't mean that if there is something that was incorrect that Connor did it on purpose, but it's really easy to forget something that might seem innocuous. Might be just something like a strained shoulder that you might have seen a chiropractor for once and never thought of again, but they get those records 2 years down the road and they say, well, you said you never had any strains or sprains, therefore it's void. Does that make it so? Not necessarily. So if you're in a situation like this and if your insurer has said that they're not paying benefits because your policy is void, give us a call. We can take a look at the situation and we can certainly figure out whether or not what they've done is warranted and whether we can actually get the benefits.
Lots of good stuff always on every show. Now that we're pretty much wrapping up for the day, you can always reach out to Tamar or James or the team just for that chat. Get some information. It's key before you take one step out the door. Make that phone call, 1-855-821-5900. Email is help@disabilityrights.ca. You want to find out where you can find our radio show across the country, just go to disabilityrights.ca. And that particular message from Connor came from mydisabilityquestions.com. That's free and anonymous. You can use that anytime you'd like. Again, mydisabilityquestions.com. And we'll catch you next time on the Disability Law Show. Thanks so much for tuning in.